Hello, Kevin.
It's the Readathon, Rebecca.
It is a weekend version of the Readathon.
How could we possibly do this when there is no trial on the weekend?
Well, I didn't get to talk to you yesterday, and it's June 22nd, Saturday. Mm-hmm. You saw a little bit of the proceedings yesterday, the beginning of the defense. What'd you think?
I thought it was quite compelling.
Yeah?
I thought it was quite compelling. I thought the testimony of the bite expert was pretty good, but also the defense did a good job of trying to contain what she said, but certainly she said enough to let the jury know what she suspected those bites or marks to be that they're dog bites.
Right, of course, you're talking about Dr. Marie Russell.
Yeah,
the more I think about it, the more I actually think that the testimony of the medical examiner was probably the most damaging testimony of the day.
Their own witness,
Irina Skordo. Although I do think the plow driver, Lucky Loughran, was just a star witness. But Dr. Irina Skordo-Bello just was not a good witness for the prosecution. Just would not be definitive. Basically said could not eliminate any possibility, and really seemed to jump on the idea when presented with it that, injuries could have been the result of a fight,
Wouldn't you want somebody like that to be honest?
Yes.
Even if it's not, if it's inconclusive, or not, maybe not inconclusive, but if there are bits of doubt or that, things could be seen two ways to
100%.
say, yeah, I would much rather that than, have Troopa Procta come in and I don't know. Anyway, that's my thought.
Well, the person from the medical examiner's office you missed before her, a younger woman.
Yeah, the one they did not cross-examine.
Right.
Yeah.
She testified to multiple brain bleeds, which was, also pretty damning.
So can I just tell you just the one big takeaway, the one big moment that I loved from Friday's
Absolutely.
testimony? So it was on the cross-examination of the medical examiner, and they're kind of setting it up with sort of these small questions because I think she can only answer yes or no, something like that. So they ask, could these head injuries, could they have been caused by X? Could they have been caused by this? Could they have been caused by a baseball bat? They said, could they have been caused by a dumbbell?
Yes.
And I'm like, that came out of fucking nowhere? A dumbbell?
It didn't.
A barbell?
It didn't, as it turns out. No.
It didn't. Okay.
I have since seen there was actually a home gym in the basement of the Albert's house. There was. And so there's this idea I saw this morning. So there are all these people on Reddit.
But I hadn't heard anything about that. Again,
I know.
If they say to one of their things is, did you put your phone in this dumpster and then the SIM card in that dumpster? They know shit that they're not saying. And so when they threw out the idea that a murder weapon could have been a barbell, then I'm like, oh, they're not just fishing, right?
Well, this speaks to two things that we aren't going to hear likely, okay?
Okay.
So the guy Rentschler that we did not hear testify and will likely not hear testify.
This is one of the defense witnesses who,
he's the defense witness who, he wasn't a defense witness actually. He was a witness Nope, he was actually a witness that was contracted by the FBI to write a report.
Right.
The defense wanted to call him, but he wasn't for the defense or the prosecution. The defense wanted to call him as a witness, but he wasn't being paid by the defense. He wasn't a defense expert. He was just an expert, right?
Yeah, I still would consider that if he was being called by the defense, that he was a defense.
He was technically a defense witness, right? But that's not. He wasn't hired by the defense. So is actually interesting. Somebody online pointed this out, and who knows if it's true or not. However, given Jackson's previous patterns in court, there might be something there. Some of the questions he asked him during voir dire day are, in what other cases have you testified? Basically, he was like, we have never spoken before today, whatever. This was not planned. But he's like, in what other cases have you testified? And the guy said, well, I just testified in a case in Pennsylvania. It was a murder case. By the way, he was talking about two cases in which he testified for the prosecution. And one of the cases where he testified was when ostensibly the person had fallen down a set of stairs. And it was like, I was there to prove whether or not that was true. And another one was a murder case in which a guy said that his wife had fallen and hit her head on a sink. And he said, I was there to prove that was not true. In fact, that she'd been hit by another kind of object. And so, this could be speaking to the defense's theory of the case about other ways that he had been injured. And the person who was doing this analysis showed a photo in this analysis of the stairs going down from the bulkhead to the basement door in Albert's house, because that photo exists. And they also showed a photo of the gym in the Albert's house, which had a bunch of barbells in it. So it just made me think, is there something in his report that mentions a barbell or that mentions the possibility of a barbell, which is why the barbell question got answered. And that may have come up if he had been able to testify. So that was my thinking.
Yeah. And my only other thinking about this whole thing is like, where's all this information coming from? And they appear to have put on the stand mostly everybody from the basement, that if somebody saw that one of, they would have been impeached on that or whatever. So why can't they just, why can't the defense just call the rat? Well, it occurs to me that if there's no, if the primary participants, if none of them are talking or they're staying together, that one of them might have said something to a friend or a party that's not part of this.
Right.
So in other words, it's hearsay. Mm-hmm. So it's not admissible, and they're not even going to try, but they're going to use that information to poke holes. But anyway, that's just my thought.
But it might be admissible in front of a grand jury, because grand jury admissibility is completely different than trial admissibility.
Yeah.
So anyway, so I actually think the barbell thing probably is part of the federal case. Mm-hmm. It was a theory posited or something posited during the federal case, which is why it came up here. That is, like you said earlier, I think that is right on. You know what, Kevin, that's actually one other thing I wanted to talk about before we get to our listener questions. Mm-hmm. I am seeing some disgusting ableist commentary about Lucky Loughran online.
This is the plow driver.
Yes.
Who's a longtime friend of the Alberts, but is the first witness for the defense.
Yes, first witness for the defense.
And the plow driver.
And the plow driver. And if you go on these online forums, on Reddit, on Twitter, et cetera, there are some, pro-Albert, anti-Karen Read people, very strong, advocate type people on that side. Mm-hmm. There are obviously also, quote, free Karen Read people on the other side. And then there are people who are just genuinely curious, who have eyes and ears, who've been watching the trial. I count myself among that group of people. Mm-hmm. You can't have eyes and ears and say that this has been a clean situation. You just can't.
Right.
But there are people on the, pro, anti-Karen Read, pro-Albert, she's guilty, send her to hell side that will say literally anything. And some of them might be, I'm in that camp. Some of them might be Alberts. Who the fuck knows, right? They are saying the most disgusting ableist things about him online. And I just want to call it out and tell people if they see it, it's disgusting. Okay, moving on. We have some listener questions.
Yeah.
And 2 of them are written, and then we have some voicemails. So let's go through the written ones first. I have not vetted these, so we're just going to do our best to answer them. And if we can't answer them, we just won't. You ready?
Sure.
First question.
Married with prosecution is
yes,
us. Okay.
This is from Jessica from Alabama, and I actually can answer this one, I believe. Jessica says, how long can they obtain information from a witness for? Like, are they able to look back and see what their text messages say now to one another? Jessica, the answer is no.
Wait, so is this a question about technology, or is this a question about
legal process? It's a question about legal process and access. So you can obtain, unless they have a warrant for now, they can't obtain information from now. They would need to have a wiretap or a warrant for now, which I don't believe they have. So a warrant or a wire or, a warrant is only good for a period of time. I'm going to access the data from here to here, the information from here to here.
Which you have to spell out when you are requesting that information.
Correct.
Either from a source like the telephone company, or if you need a judicial warrant, it can't be open-ended. Certainly not going forward. So that's a great question, though.
But it doesn't mean...
Because wouldn't you love to know what they're texting each other now?
It doesn't mean that unless somebody couldn't be surveilling them now. Like the FBI might be surveilling them now, some of the parties.
Sure. There definitely could be another party like the feds that are currently doing that.
Yes.
And I got to tell you, if I was looking at wrongdoing by those people, if I had a suspicion and I had enough sort of probable cause, I would be going to a judge saying, this is the perfect fucking time to find out what they're saying to each other.
Right.
Because everything's active. Anyway.
That being said, if these people are smart, they are not calling and texting one another right now.
Yeah. So the defense isn't going to pull up something and say, didn't just yesterday you say this?
Exactly.
Okay.
All right. Next question. This is from Amy Lou from Salisbury, Massachusetts.
Salisbury Beach.
Yes, not far from, it's not close to Canton, but it's also not far from Canton.
No, it's North Shore.
Okay. Amy Lou says, my thoughts are very similar to yours. I feel like there's something going on with the Alberts and McCabe's, and they are hiding something. Murder, I'm unsure, but I believe those are dog bites on his arm. Mm-hmm. I don't know if we can place him in the house or not based on the witnesses thus far, but I do believe it's also shady across the street guy's camera didn't capture or whatever. I think maybe some yelling happened between John and Colin or Higgins. Maybe Colin punched him. The dog attacked John. He fell back hard on something. The reason I think Colin is that he's family for Alberts and the fist.
The fist, yeah. Obviously.
I think maybe that he didn't go down immediately. immediately and they didn't know he died. Then they realized, and Jen told Proctor, and he believed it, and the rest followed suit as he is a cop, although I don't understand the lack of a shoe. But I would say that Karen is not guilty. All right, Amy Lou, thanks.
Yeah, so my thoughts on that is, we according to the medical examiner, the cause of death was hypothermia, with other things with contributing factors like the blunt trauma. So it reads to me like something happened in the basement. There was a fight, and there was fuck you, get the fuck out of my house, getting picked up by his petard and tossed into the snow. Maybe not intentionally trying to kill him, but definitely like, I don't care for your safety and well-being because something bad happened here, and so just take your medicine in the snow, and then hours later they realize he's dead.
Well,
it happened on Yellow Jackets.
Here's the thing, though. When did that happen? Because if we're to believe Lucky Loughran, he wasn't outside at 2:30 in the morning. He wasn't outside at 3:30 in the morning.
Well, how's long to die in the cold, Rebecca?
But he wasn't outside in the front yard at that time.
Right.
So they must have moved him at some point, or he was in the back, or he was in the basement.
Or this didn't happen until after that.
Or exactly. So one of the questions...
He was alive and well the time Karen got home. Yeah.
One of the questions that Little asked the medical examiner yesterday was, could the contusions on the back of his head be caused by dragging?
Oh, okay.
Did you hear that?
I did not.
That came up.
And so what was the answer?
Possibly.
It could be, possibly, yeah.
Everything was possibly.
Possibly, yeah.
So that was interesting. And, given the presence of the Ford Edge, the alleged presence of the Ford Edge in front of where the body may or may not have been, it makes me wonder a couple of things.
By the way, was that known information?
That was information that came up during Lieutenant Tully's testimony.
Okay.
And he said that the person who had seen it wasn't a reliable or was a witness who had changed their story several times. That was Lucky. I went back and read Lucky's interview with Proctor and Buchanan in August of 2023. The story is the same. Spine of the story is the same. Details are largely the same. The story has not changed. I don't know where this idea is that he changed his story multiple times. He hasn't. He told the story in February of 2022 to the defense investigator, whose name is also Paul, not Trooper Paul, but another guy named Paul. He told that exact story. He told the story in August of 2023 to Buchanan and Proctor. And he had told the story to Turtle Boy, which is why Buchanan and Proctor wanted to talk to him, because he had been published in Turtle Boy. And he hasn't changed his story. No. His story has remained the same.
It might be like small details that are different and inconsistent, but the general assertion is
and there's this silly idea I saw that he somehow remembers the times that he didn't see the body, but he doesn't remember the time he didn't see the basketball hoop. On the stand, he said, I'm willing to give you a time for that. Just give me a minute to estimate it. And they were like, nope, you don't remember. The reason that doesn't come to mind is because no one has repeatedly been asking him about a basketball hoop for the last 2 years. If you give him 10 minutes, he could figure out when that happened, probably roughly, right?
If you pass that house and remember something, and then 12 hours later you find out there's a dead guy there, that's going to pop into your head. It's not like, I wonder how long ago, was that the night that I hit the basketball hoop?
Right.
You immediately remember that, seared in your brain.
Also, he talked to a defense investigator about it 2 weeks later. He gave an interview about it. He gave a police interview about it. So that's top of mind. The basketball hoop, that was probably the first time he'd been asked about it in a long time.
It's close to extemporaneous.
It's so silly. Yeah. Okay. So we also have some voicemails. Should we listen to those? I have not listened to any of these, so I don't know what they say.
Let's cue them up.
Here's the first one.
Hey, Kevin and Rebecca. This is Satoria from Indianapolis. Feel free to use my name or feel free to bleep it out to keep things more fun and interesting. I have a question about the potential for a civil lawsuit in the future from Karen Read. Assuming that she is not convicted, do you think she will then turn around and sue the state, the district attorney's office, the police? And if so, what do you think is her likelihood of being successful in that endeavor? I know that it is, difficult to succeed against the state government, but it's not impossible. And of course, there's a federal investigation too. So I assume that, she might wait till that's over, but who could say? Anyways, I'm just really curious what your thoughts are in general. And just want to say I've been loving the coverage of this case. I wasn't following it. I'm still not really going into a deep dive. I'm pretty much only relying on Rebecca's recaps. So I really appreciate it. I've been really enjoying it. I don't typically follow live trial coverage because I think that, more often than not, trials can get won on showmanship versus the actual evidence. So I just kind of prefer to hear about it after the fact, but not this time. This time I am riveted, just like Rebecca, and I have just been enjoying following along with the rest of the Crime Writers On community. Looking forward to the 1,753,000 podcasts that will be coming out in the future, or, docuseries and books about this case, and I hope that Karen makes some money off of some of them at least. Anyways, have a great day.
Yeah, she's got to get that taillight on her Lexus repaired.
Yeah, I saw a tweet that was like, so the state's going to be, after this is over, returning her Lexus to her completely repaired and in great condition, right? Apparently there is allegedly a Netflix crew following her around and documenting all this. She was seen on the street with them last weekend in a pair of expensive sandals that people criticized her for wearing. Fuck you guys. She can wear whatever the fuck she wants. Anybody can.
She has money. Remember, she's not alleged to have struck him with her Hyundai.
That's true.
Okay, so my thought on that is like, anybody can file a suit for any reason. I feel like as far as the likelihood of success, if she's acquitted and nothing further happens, then she has a kid. She's gonna have to count on a civil jury kind of seeing the conspiracy too. Although there's, and sort of going with it, even though they can't present the evidence because they have to present an affirmative case.
Right.
If there is there's further action, such as she's acquitted and they arrest somebody else, or if she is acquitted and the feds come in with something else that they can point to, basically to say, I'm not guilty. I won at trial. I don't know how strong that is unless you can point to other things that said, not only was I wrong at trial, but you guys knew all this other stuff and you proceeded anyway.
Yep.
So that's what I think, and it's just a question of whether that can come out.
Yep, and it can. Mm-hmm. In a civil case, you can bring all sorts of stuff you can't bring in a criminal case.
Yep.
You can have people give depositions on the record. Mm-hmm. She would be able to bring in those guys that the FBI hired. Right. She'd be able to bring in, and she'd be able to show the prosecution had this report. The police had this report. She would be able to bring in the grand jury testimony. She'd be able to bring in all of the stuff the prosecution knew. She would. I believe she has an excellent case if she is acquitted. I hope, this is probably not the case, I hope that Alan Jackson's firm has a civil litigation arm, and so that they can reap some of the benefit of this. Listen, I'm not heroizing. I'm not canonizing Alan Jackson. I know that he's a lawyer. This is his job. He has defended also some people that I fucking hate. That being said, he is doing a very, very, very good job at his job in this case and representing this client very well.
So much to work with.
And also, I think
Harvey Weinstein, there was not a lot to work with.
Yeah, I think his career is going to do really well, even better than it's been doing after this. I think he's doing fine anyway. But if
the card didn't hit, you must acquit.
But remember, there's a bunch of stuff that her defense team has that they have not been able or allowed to present at this trial that they would 100% be able to bring to a civil case, including all of that federal stuff. 100% she's going to sue.
But in a civil trial, she wouldn't have to. It doesn't matter whether she can prove that she's innocent. She'd have to prove that there was malfeasance on part of the prosecution.
Yep.
Which
is.
As I keep saying, man, these prosecutors are committed to the bit.
Yes.
They are committed to this.
We have eyes and ears.
Yeah. All right.
Next question.
This is Tara Isaacson from Salt Lake City, Utah.
Hey.
I'm a criminal defense lawyer, and I've been listening to most of the trial. It's been super interesting with really high-quality defense lawyers and really interesting issues. But one question I had was, why did the judge rule, and she must have done it pre-trial, that the defense could use the materials from the federal investigation but couldn't talk to the experts? I was curious as to what her rationale was. I looked online just briefly and couldn't really track it down. So I thought that was interesting. These are clearly really top-notch experts. They would be incredibly expensive to retain, but they are clearly top of the line. And then the expert from California, who's the dog bite expert, she's super brilliant and fascinating. So loving Rebecca's coverage on this. You're welcome to use my name. This is really awesome.
Now, did the judge issue a written finding or just from the bench?
All right, so I can tell you about, they actually can't use the material from the federal investigation. They can bring up the existence of the federal investigation in questions, but they cannot actually say what it was. So what you'll hear him say in questions is, you testified at another proceeding. She actually sealed all of the federal stuff and said it cannot be used at trial, and I will consider matters individually as they come up, one at a time, was actually her essential ruling.
Yeah, and I think this question is about, okay, so this is the splitting the baby that the judge did regarding the federal trial. You can't talk about, you can use anything, any information that got
to ask questions,
but you can't refer to a grand jury, you can't pull out testimony, et cetera, et cetera.
You can't say, read this thing you said to the grand jury.
So the question is, well, if the judge allows that, why would the experts that testified there be off limits?
It's interesting it's an interesting question. Can I just throw out a theory?
Yeah, sure.
I think if these experts weren't the product of a federal investigation into this, it would be a very different situation. I think there's some jurisdictional fear going on right now. Her claim is that she doesn't know what all information these experts were given to come to their conclusions. That's her claim from the bench. But she also doesn't know what all information any of these other experts were given to come to their conclusions.
Right, because they drew their conclusions off of publicly available information. So the implication may be there are variables that are not disclosed by the state or are unknown, and so that they may be drawing faulty conclusions, which seems like kind of a double standard.
I think what she's thinking
especially if it's exculpatory.
I think what she's thinking is the feds might have a different objective in their investigation. So the information given to the experts might be toward that different objective. That's kind of what she implied.
Yeah,
that being said,
they're empirical facts, but yeah.
It's totally bullshit, especially given if you listen to yesterday's recap, I dropped the tape of Dr. Irina Scortabello saying that she could not make a determination, and then she described exactly the person who could, and it was Dr. Rentschler. It was exactly him.
Yeah, this was the prosecution's medical examiner saying the only way to determine that thing would be if you were this kind of expert, which the judge had just disqualified.
I felt like that was very intentional on her part. I really did.
Could be, yeah.
I did. I
or
felt
certainly
like
seemed like
it was pointed.
It seemed like it could have opened the door. I think the defense could have approached and said,
maybe they will.
Your Honor,
maybe they will.
You know, the prosecution just said that the only way to answer this question would be they opened the door.
Maybe they'll file a motion.
Yeah.
All right. Next question.
Even with just limited terror.
So here's a question for you, and something that I have a theory on. I'm wondering if the reason that the case is going so slow is because the prosecution is biding their time trying to figure out if the feds are going to charge anyone. I don't know. This came to me last night. What do you think?
So let me go first on that. I think that whatever the feds are probably waiting to see what happens at the state trial, not the other way around. One of the reasons why it's going so long is because the way this trial's been scheduled, which is really unusual. Well, that is one. But that is a contributing factor, right? I mean, if you have a murder trial and you're meeting twice a week, I mean, it's going to go twice as long as it probably should have, right? I mean, what are they on day 28? 27?
Yes, but it doesn't matter. Yeah. The defense is going to take 2.5 days or 2 days.
Yeah.
And a murder trial, it doesn't take this long unless you're O.J. Simpson or Karen Reed. It just doesn't. The reason it's taken so long, period, is because they don't have any evidence, and they are building a house of cards, and building a house out of cards takes a whole lot longer than it does to build it out of cinder blocks.
Well,
that's why. That's why.
I'm going to I don't know if this is a disagreement, but as far as like, if we're going to add up the hours, you're going to say, oh, the defense is only going to take 2 days. I feel like a lot of this trial has been driven by the defense, and the defense has hijacked the prosecution's case during its cross-examination. If the prosecution had just put out all these state troopers, then I think the defense would have called a lot of the people that the prosecution did, would have called the Alberts that they did and the McCabe's and, those people. And I think that the prosecution intentionally tried to get those people on because they thought they could control the narrative. They could blunt anything about
Jennifer McCabe's phone.
Yeah, I mean, we saw this in the Trump trial, right? Like the prosecution wanted to bring Michael Cohen on. They kind of downplayed it. And this happens a lot. You want to be able to say, yeah, our guy sucks, but they don't want, the defense to come up and say, he sucks and be a big surprise, right?
Yeah.
So I think that if you in football, it's called time of possession. And I feel like if you looked at the time of possession on this, that the defense is a lot more robust than just 3 days of testimony.
100%. But the prosecution also put on a bunch of repetitive witnesses.
Yeah, sure.
Which was not necessary.
Because I feel like the whole that a big part of the prosecution is just playing defense against the defense.
Oh, yeah.
Right? Anticipating what the defense is going to say and try to preempt it.
Isn't that what you would do if you didn't have any story to tell? They don't have a story to tell. They have not, Kevin, a single time said, here's what happened. Here's what she did. They have not said that at all.
Yeah.
Okay, ready? Next one.
Yeah.
Hi, Rebecca and Kevin. This is Diane Calhoun. I've been following the Karen Read case pretty closely. Did I hear the DNA report say there were 2 male DNAs on both of John O'Keefe's shirts? I mean, that could be big if we know who the second one was. Thanks. Love your show. Bye-bye.
Yeah, that's a good point.
I don't know where the source was, the shirt or the glass or something. There were 2 other male profiles found on some of the evidence. I'm going to tell you something. I don't think it matters.
Well, okay.
Because I just don't. Because he was in a bar with all those dudes that night.
All the dudes at the party.
Yeah, I mean, he wasn't in the bar with Colin, but he was in the bar with.
But if that's Colin's DNA.
But he was in the bar with Colin's dad.
Yeah, but if it's Colin's DNA.
I understand
not
that.
the familial DNA.
But the handling of the evidence, the contamination, I just don't think it matters. I just don't. I don't think it matters any more than the pig thing matters.
I think if you found out the answer, that maybe it doesn't matter because you're right, it doesn't. If it is exclusively the DNA of somebody, that the only place he could have interacted with him was inside the house, that's a big deal. Now you're saying it's probably unlikely that's what that DNA is, but you don't know. Particularly because I think the DNA is probably, if he were assaulted inside the house, I think that the probability is very high that the DNA is the assailant. And not somebody who passed a pitcher of margaritas. I think that yes, the potential is there for that to be like really important evidence, but we just don't know. And did nobody test that DNA?
No.
No one tested the DNA.
They know it's pig
DNA on the arm.
Yes. Which, by the way, I actually do buy the dog treat answer.
Yeah, I do. Yeah.
Because it's there. How else would pig DNA get into the arm or shirt? How else?
Yeah, it's not.
He didn't rub pork on his shirt.
Yeah, no.
All right, you guys ready for the final question?
Mm-hmm. Yeah, final question. Go for it.
Hello, Kevin and Rebecca. This is longtime listener Michelle Womble.
Hello.
And I really don't have anything to say. I just thought it would be fun to make a memo. It just sounded fun. So thanks for covering the Karen Read trial. It's pretty fascinating. I can't wait for Netflix or whoever to do a series on it. Hopefully it's a dramatic reenactment. Anyways, I don't know what I'll do next week whenever we can't hear Judge Beverly tell Mr. Lally to speak up.
That's great. What do you think would be a better telling of it? Would be a documentary or the docudrama? With an A-list cast.
Oh, who's gonna play Karen? For A-list, it would be for A-list, it'd probably be Sandra Bullock. Yeah, it'd probably be like Sandra Bullock.
I think she
A-list.
aged out of that. But.
Oh, you think so? They're what, like in their early 40s?
I guess.
Sandra Bullock's in her straight 50s, but she looks a lot younger.
Which is not to say what is the thing the Don Lemon said on this? He's like, she's past her prime. I'm not saying that. I'm just saying as far as casting goes, I don't know. It doesn't fucking matter.
No.
I think that would be really interesting, especially if all the cards get laid on the table.
I think the documentary is going to be fucking great.
Yeah.
This is all the makings of like a Making a Murderer type situation. Here's the thing that like I think about again and again and again. I'm just
I see John Hamm as the FBI agent that we haven't seen yet.
I'm going to go on a limb and say, as much as I don't think John O'Keefe has come out in this trial as coming off like a particularly likable person, he is dead, right?
Yeah.
And his family has been sitting there this whole time. They hate Karen Read. They fully buy the narrative that she killed him, and they are disgusted by the fact that she's sitting there and feeling any satisfaction at getting justice, or feeling like she's getting justice, and they're just and I feel fucking horrible for
I can
them.
understand that. I think
feel
it's very
horrible
normal,
for them, because when this is over, if she's found not guilty, which at this point it's so hard to imagine she won't be found not guilty, or at least have a hung jury.
Yeah.
Do you believe in any way that the state is then going to pursue another suspect in this crime?
A different suspect?
Yeah.
No, I think, okay, well, if she's found not guilty. Okay, all right. So I was going to say if it was a hung jury, there's no way. They're going to retry her. I bet they'd offer her a deal, take this deal, and all you have to, and then it's over, and she's going to say, kick rocks because I didn't do it. No, I mean, are they pursuing the Tardy Furniture killer now that Curtis Flowers has been exonerated? No, they don't do that. But man, it's just, they have so much, I was going to say pie in their face. They just look so badly. It just feels like for no other reason, these political reasons, they need to solve this case. And it's certainly, I don't know. I just can't believe that within all the people working in that district attorney's office, that there isn't one of them saying, I find this defense evidence compelling, and we might have gotten screwed here. And anything that Trooper Proctor is on, fuck that investigation, because I'm not bringing him or Trooper Paul to trial with me on anything. Yeah,
they should be on a list. If they're not on a list after this or fired after this, or Proctor should be fired.
They're on the mental list.
Proctor should be fired. Paul needs training, and he needs to be moved to a different unit, right?
Yeah,
that's pretty clear. One of the things that I told Jamie briefly yesterday that I'll tell you, because I think that it's a fact that you'll find interesting, that Lally has prosecuted another murder case in which somebody was accused of hitting somebody with their car. And he lost that one.
He lost that trial.
Yeah.
Oh, phew.
So he's definitely the man for this job, as Jamie said.
It's like that Italian prosecutor who keeps who charged both in the Monster of Florence case and Amanda Knox that there was satanic overtones to these murders. It's like, that's your kink, man. Okay, but it's not real.
Hey, by the way, a listener pointed out after on Patreon, after I made one of my tirade yesterday about the Apple phone not counting steps when you're in a car, ever. She said that her niece claims that she was tubing behind a boat on a lake and it counted tens of thousands of steps. I have two questions.
Yeah.
What the fuck was your niece doing with her tube?
Oh, Jesus, yeah.
And her tube behind a boat. And two, did you see said steps?
I have a theory, though.
Sure.
That, it's
jostling?
Well, it knows that you're going upstairs not because the camera's on or something like that, or your geolocation. It's the gyroscope inside. It understands the motion.
It does.
So it's not going to confuse you being in the car.
That's not a theory. That's actually how it works.
Well, but tubing, you're bouncing around. You are covering ground. So, that it should register something. I could see why it would incorrectly do that.
Yeah.
What was the thing? People were skiing? How about this? There was, with the new iPhone, there were people who were skiing, and the emergency alert thing on the iPhone kept going off, calling 911, assuming these people were in car accidents.
Oh, man.
Right? So technology doesn't always work the way one thinks it should, but that's why they bring in technology experts to say, no, you're fucking crazy.
Well, briefly, I think on the defense witness list coming up, they're going to present one more day of testimony, they say, and we do have a crash reconstruction expert or two coming up, and I may be one more technical expert. I'm not certain. So it should be an interesting finish to Alan Jackson and David Yanetti's case and Little's case. I'm really interested to see how it finishes off. What do you think, Kevin? How long do you think the jury will deliberate in this case after closing arguments?
Oh, I think a day.
Really?
Yeah. I think they could take a straw poll first thing in, but that probably, the 20-minute decision isn't really a good look either way. But, I think I think they're like, we want to stick around. We want to have everybody talk. Let's have them bring in lunch one more time.
That's how
I don't know.
No, that's how it works. I'll tell you that when I was a foreman on a jury, I did a straw poll. We all agreed not guilty. And then I said, we should still talk about it anyway, because I wanted to be able to say, like, will we be able to justify this? You know, it's not like you get asked questions, but like, you know, sometimes juries do get asked questions later by somebody. And I was like, we should talk it through so that we all know why we're saying this.
Yeah, actually, the judge talked to you, the jury, afterwards, and kind of asked, you know, some curious questions.
Yeah, well, curious questions, but also just said that we did a good job. And, you know, how did we enjoy the experience and blah, blah, blah.
Yeah, well, that was like one day,
but
right?
But this jury is going to be able to talk to the media and so forth afterwards. So if anything, I would say to them, they're not listening to this podcast, obviously, if you take a straw poll immediately and you know she's not guilty, it take at least 4 hours, take half a day, enjoy your lunch, the free lunch, and talk through all the reasons why you're saying not guilty so that you can have practice saying them so that if you decide to talk to someone later, you've already said them to each other.
I say best practice is to not do that, because if it's then 10-2, those two, in some cases, will feel compelled to defend their position.
Yeah.
As opposed to, certainly the other 10 are, you know, this isn't 12 Angry Men where like all of a sudden the other 10 will eventually be persuaded to change their votes, to be pressure, et cetera, et cetera. I think there was that one OJ juror who, you know, held out but said, okay, fine. Can I just add like one thing that I learned besides the dumbbell?
Sure.
So there's like, you know, goofy stuff online, and somebody like did an immediate animation of Lucky's
plow
ride, you know, and it was like, okay, you know, it was very well done, you know, going by the house, and if you'd seen a body, blah, blah, blah. And what I needed to visualize and see was that if accurate, you know, to what the alleged facts are, that when we say that the driveway was on one end of the property and he was discovered in the front lawn, but all the way at the other end of the property.
All the way at the other end of the house.
If you can imagine any house, it doesn't have to be a big, luxurious house. Imagine any house, your house, neighbor's house, friend's house. Imagine that the driveway is on one side, and you think about the far end all the way. Whether or not that's 50 feet, whether it's 25 feet, whether it's 100 feet in your mind.
50 feet, yeah.
How does that body get from that end of the property to that end of the property? And if they keep saying, well, it was struck and he was tiddly-winked in the air, or that they didn't say he stumbled over, pushed.
That's what
and then tumble. It just doesn't make sense to me.
It makes no sense. And also, but by the way, his body, it's very far. It's very far from there. Their house is big, by the way, and their lawn is wide. Yeah. And his body is, in fact, in front of...
And then land on its back like a snow angel.
Right. Yeah, but it is, in fact, in front of a gate to the rear backyard.
Right. It's a direct line down from the gate to the backyard, but I just can't imagine.
But this raises questions. The one question it raised yesterday for me was if he was either dropped there, taken there, or maybe there was a plan to pick him up with a car and bring him somewhere else. Like he was put really close to the road. Was there potentially a plan to disguise wounds by saying he was hit with a snowplow? I mean, when Lucky was testifying yesterday, I just kept thinking again and again and again, this could have been Lucky on the stand. It could have been.
Yeah.
And Lucky would not have had his case in the news. We would not be sitting here talking about Lucky Loughran on trial versus the state Commonwealth of Massachusetts. We would not be. Lucky did not have the resources. Lucky would not have Turtle Boy. You know, it's just we
could raise the question of why was John O'Keefe there, but they probably wouldn't ascribe anything nefarious to it.
It would be an accident.
Yeah, and they're like, that seems uncommon that a guy would be,
And O'Keefe's family would sue the city, and it would not be murder, you know, so he wouldn't be on trial probably. But, you know, it would be like, I'm wondering, because getting hit by a snowplow could look like anything.
Like an accident.
Anyway.
Yeah.
All right, Kevin, thank you so much for sitting with me for this weekend edition of the Readathon.
Well, do you know what the trial schedule is for the coming week?
Finishing up with defense for Monday, closing arguments on Tuesday.
And then jury deliberations begin.
Jury deliberations begin, and I'm hoping we'll have a verdict by the end of this week.
Wow.
Could be. And then what are we going to talk about? We'll figure it out. All right. Thanks, everyone, so much for listening to the Readathon, and we will see you Monday.
partners in crime media.